With that, I want to quickly bring in as well Anas Tanwir, advocate on record, Supreme Court. He's also fighting the case for one of the MPs who have also filed a plea with the Supreme Court to strike down what is being alleged by the MP as unconstitutional, the Waqf law. Mr. Tanwir, now what do you make of what the Supreme Court said today? Because there is no stay on the Waqf law, which is what the petitioners wanted, but the contentious provisions, clearly there's an injunction on those, two of them at least.
See, the two most important provisions that had a nationwide and a widespread implication have been effectively stayed. So as of today and until the next date of hearing, there cannot be any appointment in the Waqf Board or the Council, and also the Waqf by user registered and declared Waqf, the nature of the same cannot be changed. So these two had a widespread ramification, and they have been effectively stayed by this Honorable Court.
Mr. Tanwir, would you elaborate on the importance of these two provisions? Because, that could be the core also of, what many of the petitioners want. Would you elaborate on them and how they tend to benefit the petitioners?
See, if the government had the power that they have taken with this legislation to change the nature of Waqf, to abolish the Waqf by user completely, that has been stopped because most of the Waqf, if not all, rather many of the Waqf that we have today were established long ago. There cannot be any registration because the one who gave this endowment are no more, their generations have gone, but it has been used as a Waqf property. This provision, the 3B provision, wanted a registration and a complete declaration saying that who instituted this Waqf, on which date, and so on and so forth. And obviously, the person, the mutawalli, has to give a certain date. If he fails to give that certain date, he will be sent to prison. Now, with the stay on this provision, it is very important to understand that there cannot be a registration change of the nature of the Waqf. The power of the collector also, a lot of the power flows from this provision only. That has also been effectively stayed. And importantly, the part where the whole Waqf Council composition was being changed, the composition of Waqf Board was being changed, non-Muslims were allowed in. Matter of fact, if we count the numbers in the Waqf Council, the numbers of Muslims might be less than that of non-Muslims in a Waqf Council. So all those provisions have been stayed for now. So it is a small but important victory for us for time being.
Well, interim victory, small though, but the defense, that I asked Mr. Owaisi as well, which was also made in court, is how, entire villages are being taken in and claimed as Waqf properties.
Yes, millions of response have been sent by Muslims opposing the Waqf Amendment. One. Second, they say that there has been deliberation in the JPC, but all the amendments proposed, all the dissent notes by the opposition members in the JPC were discarded, while all of them by the BJP members and their allies were allowed. So let them put this on record, let them bring their affidavit, we will file our reply to that. But merely saying that there has been a widespread consultation, what was the nature of the consultation? What was the record? I know for sure that millions of Muslims have sent emails opposing the Waqf Amendment. Now, will they bring that on record? Will they bring that number also on record? Because we might try to find out how many have sent. So we will have to see, we'll have to wait for the affidavit to come. Once the affidavit is before us, I will be in a better position to respond to this.
Okay, you're talking about the affidavit, which the government has to file in 7 days' time with proper paperwork. Away from all of that, do you now, at least there is a realization that the law will stay, but you'll have to take the fight provision by provision?
See, let me just, for the court has said that the matter will be listed in the week commencing 5th of May. Okay, not 5th of May. So a lot of people have been saying that the next date is 5th of May. That is not the case, first. Second, yes, we are quite happy. I mean, we will be pushing for more stay. We have already argued that there are other provisions also that have to be stayed. We will be pushing for that, and we are hopeful of the outcome on the next date of hearing as well.
All right. Mr. Tanwir, now your particular petition highlights issues like the precondition of 5 years of practicing Islam for creating Waqf and restrictions on Waqf. How will you argue that these provisions are arbitrary and violate Islamic law and customs, because you will go into provision by provision?
They not just violate Islamic law. Please understand, they say practicing Islam. How do you establish if someone is a practicing Muslim or not? And why should I establish this to any government agency or to any representative of the government? It is between me and my God. And state has nothing to do with it. So this provision is constitutionally arbitrary. It creates a different class. I have also filed another petition representing the MP from the Lakshadweep. He belongs to Schedule 5 area. And there is a complete ban. The amendment puts a complete ban on creation of Waqf in the Schedule 5 area. And it's Schedule 5 area or Schedule 6 area. Now he's saying that how can you ask me to choose between my religion, my religious identity and my tribal identity? They both are protected by the Constitution. They both are sacrosanct to me. And that is the crux of the case. The state cannot force me to prove that I'm a practicing Muslim.
Okay. One final question that I'll ask you, Mr. Tanwir. Your petition has focused, your petition in particular, on the fact that Waqf Act somewhere down the line violates Article 14, the principle of equality. Now, with what the court said yesterday and today, if we call it an interim order, do you think it's encouraging for you going forward?
Yes, it is quite encouraging, and the court's view has not been against us. It has quite been in our favor. But as I said, these are deliberations. Whatever happens in the court, unless it is recorded in the order, it remains a deliberation. A lot of time judges say things to prod the response, to get a response from the councils. So it will be wrong to say that the court has framed a positive opinion or a negative opinion. The matter is still sub judice. We are still on a stage where an interim stay will be further requested. So I don't think the court has framed. I mean, it is positive for us as of now. But the hearing is not over. It is still sub judice.
True. And you're approaching it with caution is what you said. Appreciate you joining us.